Welcome to everyone. We appreciate you joining us for this week's installment of Bond's Business in 2023 weekly webinar. We're going to start off with our normal COVID update today. Thank you, Kathy. The numbers look good. You know, we've seen this relatively flat curve for the past several months. We've seen actually a little bit of a decrease actually over the past 90 days. Average daily cases on February 27th were 2,339. I actually went back and looked at approximately this time last year, and we were in the 60 to 80,000 cases per day range. So the numbers are significantly improving, continuing to improve, and we haven't seen any new COVID restrictions in place. Next slide, please. The colored picture of New York State verifies or shows exactly what we're seeing. A lot more yellow, a lot less orange, even light orange, and certainly less dark orange or red. The numbers on the chart on the right show some significant percentage increases, but as I say, every time we look at that, you have to understand the context of those numbers, particularly in counties like Lewis, where 4 cases per day is the daily average, but we've seen a 40% increase. So it's not a significant increase in numbers, only by percentage, just based upon the extremely low case numbers in those counties. So that is it in terms of COVID updates. I reported last week on a decision from the Onondaga County Supreme Court relating to healthcare, the New York State healthcare vaccine mandate. The state of New York has filed a motion to stay the decision of the Onondaga County Supreme Court with the Appellate Division 4th Department. And when I reported last time, there still had not been a decision on the motion for a stay. And I can continue to report that there still has not been a decision on that motion to stay. So we will certainly update you if we hear anything new on that front, including on our blog, which hopefully all of you are signed up to receive. Okay, so we're going to start off this week with a recent decision from the National Labor Relations Board regarding settlement agreements. And I know that sometimes when we present on NLRB decisions, those of you who are in non-union settings turn off. But I can tell you that on with respect to this particular decision, you don't want to turn off and you want to make sure to listen. So here to talk to us is Pat Malfi. Pat's a member in our Syracuse office, and Pat closely follows these NLRB issues and does a lot of work with respect to the NLRB for our clients. So Pat, welcome.
Hey, good afternoon, everyone. We're going to talk about a case called McLaren-Macomb, which involves a hospital in Michigan that has 2,300 employees. And the setup is something we're all familiar with. During COVID, they laid off 11 people because there were no elective surgeries. They offered those 11 people a severance agreement that gave them some money and had 2 provisions. And I want to read the provisions because if you're using a severance agreement, this is going to be somewhat familiar to you. The first provision is a confidentiality provision that said the employee acknowledges that the terms of this agreement are confidential and agrees not to disclose them to any third person other than his spouse as necessary for professional advisors, legal counsel, or tax advice, or compelled to do so by a court. Now, if you're using a severance agreement or a settlement agreement and you have a confidentiality provision, it probably sounds like that. Mine personally limit them to spouse, attorneys, and tax advisors. The next provision was called the non-disclosure provision, but it actually was a non-disparagement. And that provided that at all times hereafter, the employee agrees not to make statements to employees, the employer's current employees, or to the general public, which could disparage or harm the image of the employer or its parents and affiliates. So the punchline is the NLRB believes those 2 provisions are unlawful on their face, which may be a surprise to some of you, but the sky is not absolutely falling. What the board said is offering an agreement, and it says these 2 agreements chill or unlawfully interfere with employees' Section 7 rights, which include the right to strike, the right to band together for mutual aid and protection, discuss terms and conditions of employment, and down the line. So the board said, and it doesn't matter whether or not the employee signs the agreement. And I think this is what has caught a lot of people and confused some folks. The board says offering the agreement with these provisions unlawfully threatens employees with loss of benefits by conditioning the receipt on the acceptance of coercive terms. So the board thinks these two provisions are coercive. Now, remember the context here. These folks are no longer employed. They've been terminated. And we're talking solely about what is in the settlement agreement that I give to you, and it is your voluntary choice to sign or not. And that's what the hospital in this case said. It's purely voluntary. It's not coercive. And the board completely disagreed with that. So what about the confidentiality provision did the board find unlawful? Mostly, it was primarily concerned with the fact that it was limited to only 3 entities: lawyers, tax professionals, and your spouse. And what the board says is Section 7, my right, union or not, to engage in Section 7 protected activity includes talking to third persons about whatever my employment problem may be. And they gave us some examples: judicial, political, newspapers, social media. So now everybody who's listening to this, the reason you have a confidentiality provision is you do not want your employees going to the newspapers or posting stuff on social media and down the line. So we have a little bit of a concern with what they believe about the confidentiality provision. What about the non-disparagement provision? The first thing they had a problem with the non-disparagement was that it didn't define what disparagement meant. Okay, I can maybe see that. And they reverted back to a long line of board cases that basically say, unless what the employee says is so disloyal, reckless, and wait for it, maliciously untrue, it can still be protected by Section 7. So in a fairly long around the barn decision, the board said these two provisions on their face are unlawful. And if you want to use them, they have to be narrowly tailored. And this is my favorite part of the opinion. They drop a footnote where they say, essentially, we are not called on, in this case, to define today the meaning of a narrowly tailored forfeiture of Section 7 rights in a severance agreement. So what they're saying is, maybe you can do it, but we're not going to tell you how. And that's kind of infuriating, but we can deal with it. The first thing, I think, in the RIF context or reduction in force severance agreement, I am of the opinion personally, because I think a lot of people may disagree with me, that the non-disparagement provision is probably more trouble than it's worth. It's very rarely enforced. And if you are having, the bigger the RIF, the more likely a lot of these employees are talking about an employer in less than generous terms. And it's impossible to police that. So I think the one thing is and as we go through this, there is no one size fits all fix to this. It's all really dependent on your risk aversion or your risk tolerance. And as we get into, so I think the first thing I would have you think about is, do I really want the non-disparagement provision and why? The second one, and I think more people would be very concerned about, I don't want to let go of the confidentiality provision. I don't want them talking about it. And the first thing I would say to that is there's a spectrum. There's a range of things where that might apply. If you have a large reduction in force and you have a set formula for what the benefit's going to be, and if you've had to do the OPA disclosures, which are the Older Workers Benefit Protection Act disclosures that basically list every job title and the age of everybody who's being terminated, I would have you think about, what do you want to be confidential at that point? Because everybody knows. Now, on the other end of that spectrum is the single employee who you've given a severance agreement to, and you do not want the number, how much that employee has gotten, to be distributed. And how can you keep the confidentiality provision and still narrowly tailor it. You can, I think. Now, there's more than 200 lawyers at Bond, and I probably going to guess that there's more than 200 solutions to this particular drafting issue. I have my own, and I'm gonna throw it out as kind of a concept, and I'm sure all of my partners will beat me down like it's whack-a-mole, but we're early in the process. I think that, you know, we went through this before, maybe 15 years ago with the EEOC charge filing ban. So you will see in your agreements, if you have a reduction in force agreement, there's that line in there if you're working with us that says, nothing in this paragraph or this agreement generally prohibits this employee from filing a charge with the EEOC. I think there's a fix that can be done with this problem that's very similar to that. There's all kinds of drafting issues and placement issues that I think as you're working through with the bond attorney you normally work with, you get a comfort value as to where you want to, how aggressive you want to try and be with the language, or how non-aggressive, and maybe you want to even let go of the non-disparagement provision. There's a lot of solutions to this. I think the point that I want to get to today is the board says there is something out there called a narrowly tailored agreement. We're not going to tell you what it is, but if they're telling us it exists, then there's a solution. And it's, I think, primarily in drafting. So the sky isn't falling completely. It's just another example of the board changing the law back to what it used to be during a different administration. So that's the update.
Pat, thank you so much. Now, for those of you who have questions about how this is going to impact your settlement agreements, reach out to Pat, reach out to whatever bond attorney you typically work with, and we can walk through the pros and cons of various approaches in that regard. All right, thank you, Pat. Before we move on, I always appreciate the questions we get in the Q&A section. Someone asked me a question after I did my introduction about the healthcare vaccine mandate decision from the 4th Department. And although I checked this morning and there was nothing there, I went back on while Pat was presenting and double checked. And as has happened several times on this webinar, the appellate division uploaded an order in the last hour from the 4th Department that granted the state's motion for a stay of the DOH vaccine mandate during the pendency of the appeal. So for now, the vaccine mandate is back in place and will remain in place until the appellate division hears the appeal. So we will update our blog. We'll provide a link to a copy of the order. But for those of you who are in healthcare and this directly impacts you who are on the call, I wanted to give you some breaking news. All right. Next up, we are going to have Jeff Keel and DJ Nugent on. Both have presented many times on this webinar. DJ usually by himself, Jeff usually with his partner in crime, Lou DiLorenzo. But today we thought it would make sense for Jeff and DJ to present together about tips for drafting employment contracts. So Jeff, DJ, welcome. Thanks.
Okay, thank you, Adam. Good afternoon, everybody. I'm going to talk generally about thinking about employment contracts. And then DJ is going to give you some information you can actually use. But let me start with being in law school and having my father figure out that I had given no thought whatsoever to what I wanted to do with a law degree. And he sent me to see one of his friends who had been practicing for a long time. I walked into this guy's office. He looked like a grumpy bear who had just awakened from hibernation. He said, "Kid, all I want to know is, are you interested in takeoffs or are you interested in crash landings?" And I said, "Yeah, you know, crash landings sound pretty good." So I decided to become a labor litigator. You learn a lot from litigating employment relations that have gone sour. And the two things you learn the most are when people have not adequately planned to express what they have agreed upon, and when people have not adequately planned for what happens when the relationship needs to be ended. You need to plan for both, and I'd like to talk about how we orient our thinking to that for just a little bit today. There are a lot of good reasons for having an employment agreement. You can also do a term sheet. You can have an employee handbook. But there are good reasons to have an employment agreement, especially when you're dealing with special employees or highly compensated employees. And there are good reasons for that, even if you don't want to commit to a specific period of time that you're going to be bound to employ that person. You really do want clarity of understanding as to salary. How are raises going to happen? Will there be incentive compensation? How is it figured out? Is there vacation, sick leave, other leave, personal leave, other than what the law requires? Are you going to be dealing with retirement benefits? And I'm not going to touch that one, but DJ will. Are there promotions as an issue? Are there performance reviews? Or is there compliance with company policies? And that's a whole range of things you need to think about, but you need to think about also what you actually need. And I'll come back to that in a bit. But I think that overbreadth is generally an enemy of reaching clear understandings. Now, you might say to me, okay, you said I can do that, but what if I don't want to commit to employ this person for a specific period of time? If it doesn't work out, I want to let him go. Not a problem. You can have an employment agreement, which is an at-will agreement. New York, in fact, is an at-will state. But I do have to tell you, if you're going to enter a formal employment agreement, and it's going to have all these other nice provisions that are very important to both parties, it would be a good idea to address that. The traditional way, I think, is the blunt one, a clause which says your employment is at will and may be terminated in our discretion at any time and without penalty. If you want a kinder and gentler version of that, I have sometimes put it in saying, you may employ this employment relationship at any time without penalty, and we, of course, reserve the same prerogative. Now, you may also want or need to offer a specific term of employment. I'll give you a good example. You are about to launch the new product, which is going to make your company. You're in the toy business, and this is going to be the world's first stringless yo-yo. You have exactly the right product manager whom you want to hire. She is perfectly suited to the job. She's got a great track record, and she wants a 5-year commitment from you. You can do it, but this is when you need to start thinking about the crash landings. When you're talking about that, and it looks like the stringless yo-yo is going to be the product of the century, consider the possibility that it might not be. Think about whether, if you're a year into this project and you just have determined it's not going to fly, do you really want to pay this product manager for 4 more years of either not doing anything for you or of doing some other job for which she's not particularly suited? It is not her fault that your project failed. What you can do is think about saying, okay, this is a 5-year deal, but we can terminate without cause by paying you out the lesser of 1 year's salary or the balance of the term of your employment. By which I mean, if you terminate in year 1, you pay out a year. If you terminate it in year 4, in March, you'll pay out 9 months. Are you necessarily going to be able to make the deal? No, but it's something you should be thinking about. You'll notice I said that was a without cause provision. Lou and I have talked to you before about termination with cause. And when you take contracts in law school, one of the things you learn is black letter law is that any contract may be terminated without penalty if there has been a material breach of the contract on the part of the other party. Well, I could tell you that if your employee materially breaches the contract, you can terminate without penalty. But if you don't deal with that in the employment agreement, I can also tell you, you will be having a judge or an arbitrator determine whether or not your version of for cause comports with the judge's or the arbitrator's version of for cause. So if you're going to have a contract for a period of time, consider, what do you want to say about termination for cause? You can talk about theft, disloyalty, incompetence, violations of company policy, workplace misconduct, failure to give full-time and best efforts, failure to comply with the standards of conduct and performance generally applicable to people in similar positions. But again, think about what you really care about. Now, I'm going to try to move quickly because I don't want to step on DJ's toes, but notice I said disloyalty, and this will follow up on Pat's presentation. A lot of you have been reading about the fact that the Federal Trade Commission has essentially outlawed all forms of non-competition covenants. Whether or not that rule is going to survive judicial scrutiny is beyond my pay grade, but I think we all need to think about whether we really want to put non-competes into employment agreements. And as Pat did, I'm going to suggest that you can get more worried about this than you need to be. The fact of the matter is, courts don't like non-competition agreements. They're constantly knocking them down for being too long in their duration, too broad in their geographic scope, too extensive in what the employee can't do. And they worry about the fact that the employee who signs one of these basically can't make a living if you've tied them up from doing what they do in order to earn their salary. It doesn't mean that you are without any protections. If your business has truly confidential information or real trade secrets, those are protected under the common law. In fact, we have a chapter in the book, it's chapter 9, which will give you a brief overview of that. It's a really fascinating area, as are non-competes. But again, as is the case with termination for cause, if you have trade secrets or confidential information that you want to protect, don't leave it to a judge or an arbitrator to decide whether she thinks that's really confidential or a trade secret. Spell it out what it is so that you have an agreement with the employee. There are a million other things we can think about. Our time is limited, and I want to turn you over to Dan now because he will give you some information you can actually use. Dan?
Thanks a lot, Jeff. Kathy, will you be able to pull up the slides? Perfect. So whereas Jeff talked about employment agreements from a general labor and employment perspective, I want to talk about some very common issues and some tips to address these issues that we see from an executive compensation and employee benefits perspective. Again, similar to what Jeff said, there's a whole host of issues that we could talk about, but for time constraint purposes, I'm just going to discuss these three, and it's not going to be exhaustive by any means, but hopefully we'll be able to just put something in the back of your mind if you see one of these issues come up, and you'll be able to address it or know who to ask to address it. So next slide, please, Kathy. The first issue that I look at in an employment agreement from an executive compensation or employee benefits perspective is whether there's any non-qualified deferred compensation being provided for in the employment agreement. I put the definition of deferred comp up on the slide here. As you can see, it's really quite a broad definition and can encompass a lot of different payments that may be provided for in an employment agreement. If there is non-qualified deferred compensation, the provision of the Internal Revenue Code that we look to is Code Section 409A. That's not to say there aren't other code sections that are applicable to deferred comp, and particularly with respect to tax exempt entities, there are certainly other code provisions that you need to look to. But for purposes of this discussion, I'm really just going to focus on Code Section 409A. Code Section 409A sets forth rules and regulations regarding the time and form of payment of deferred compensation. Generally, if you have deferred comp that's subject to 409A, you're going to be paying that deferred comp on a set schedule, and you really have very limited ability to switch or to modify payments from that schedule or modify the form of those payments. The consequences of not complying with Section 409A can be quite negative. For instance, if I have a deferred comp payment that was going to be made to me in 2024, and we violate 409A in 2023, that deferred comp payment will be includable in my taxable income for this tax year, so 2023. In addition, I'll also face an additional 20% tax. So if I have $100,000 includable in my gross income for 2023 that I thought was going to be in my gross income for 2024, not only am I going to pay tax on that amount at my normal tax rate, I'm also going to have an additional 20% tax added onto that. So again, very harsh and negative consequences if you violate the provisions of Section 409A with respect to deferred comp. Next slide, please, Kathy. So again, 409A issues can come up in a variety of circumstances in employment agreements. The two most common areas we see are with respect to bonuses and severance payment arrangements. It's very common for an employment agreement to provide for an annual performance bonus. So for the 2023 year, I'm going to provide to the employee a bonus if they hit certain metrics. However, that bonus won't be paid until sometime in 2024 because we have to determine whether the metrics were hit in 2023. I have a legally binding right in 2023 to a payment that's paid in a future tax year. That, by its definition, is deferred comp. The second area that we see deferred comp issues come up in employment agreements are severance payment arrangements. Again, this is very common to say if we terminate an employee without cause or if the employee leaves for good reason, we'll provide the employee with some form of severance, which oftentimes takes the form of continued salary payments for a certain period of time. Again, those payments may span, it doesn't necessarily need to span, but just the potential that it may span a legally binding right in 1 year and be paid in a subsequent year, that constitutes deferred comp that would be subject to 409A. Now, there are two very important exceptions that we often try to structure bonuses and severance payment arrangements within those exceptions so that those payments aren't subject to 409A, and it gives the employer more flexibility on if we start to make these payments, can we change the time and form of payment of it? The first is the short-term deferral exception. The short-term deferral exception is tied to a substantial risk of forfeiture. And what it says is that in the tax year that the substantial risk of forfeiture lapses, if the payment is made within 2.5 months after the end of that tax year in which the substantial risk of forfeiture lapses, or within 2.5 months after my employer's tax year ends, if later, such as if they're on a fiscal calendar, we can call that a short-term deferral, and those payments are not subject to 409A, and we're not subject to those stringent time and form of payment requirements. For example, using my bonus scenario where I have a bonus in 2023, it's paid in 2024. I have my substantial risk of forfeiture lapses December 31, 2023. If the bonus is paid by March 15th of 2024, that's a short-term deferral, and we can say that compensation is not subject to 409A, and we have the ability in certain circumstances to modify the time and form of payment of that bonus payment. Sometimes the practical, financial, and operating realities of companies don't allow the company to determine whether the bonus has been earned and therefore paid by March 15th of the next tax year. The way that we address that is to say that not only did the employee need to work through 2023 and hit the performance metrics, but needs to be employed on the date that payment is made in 2024. So we're adding a second substantial risk of forfeiture into 2024. So again, short-term deferral is a way to accept those types of bonus payments from 409A, and there are certainly ways to do it. And you just have to think about what you can do and what the best way for your company to accomplish those goals are. Severance payment arrangements can also sometimes fit within the short-term deferral exception, but oftentimes we're looking at severance payments that extend beyond that 2.5 month period. Luckily, there's a second exception from 409A called the separation pay exception that helps with those severance payments. And in this instance, if there's been an involuntary separation from service of the employee, or the employee leaves for good reason, as that's defined in the regulations, we can provide the employee with severance payments for a period of 2 years. And so long as the severance payments don't exceed the 2 times the employee's compensation with some other limits attached, we can also exempt those payments from 409A as well. So again, it's just in the back of your mind, if you're seeing anything that you think falls within the definition of deferred compensation, be aware of 409A, be aware that there are very strict rules, but that there are ways to modify and fit those payments within exceptions to 409A so that you may have more ability to modify those rules. Next slide, please, Kathy. Moving out of deferred comp, the other two most common issues that we see from an employee benefits perspective, in some ways to address those, are non-discrimination in favor of highly compensated employees in employer payment plans under the ACA. Non-discrimination in favor of highly compensated employees often comes up when we're trying to incentivize an employee or an executive to come to our company, and we may say something like this as an employer: we pay 80% of the health insurance premiums of our rank and file employees, but because we really want you, executive, to come to our company, we'll pay 90% of your health insurance premiums. You'll only be required to pay 10%. Because we're paying more for premiums for a highly compensated employee than we are for non-highly compensated employees, that's discrimination in favor of a highly compensated employee. This can also come up if we're providing a benefit to a highly compensated employee that we don't provide to our non-highly compensated employees. Anytime you see some type of arrangement like that, it's important, again, just to have in the back of your head, is this discrimination in favor of a highly compensated employee? If it is, it then becomes important to understand whether your health and welfare plan is self-funded or fully insured. If your plan is self-funded, it really is an issue in structuring your benefits to that type of executive in that way. We can certainly talk about other ways that we could structure benefits to try and incentivize the executive. If you have a fully insured plan, the current state of the law is that is permissible until the IRS issues regulations saying otherwise. The IRS was directed to do that about 10 years ago and still has not done so. And we haven't seen anything on the horizon saying that they will do so. So again, if you have a fully insured plan, it's permissible for the time being, but that may change. The other common employee benefits issue we see in employment agreements is inadvertently creating an employer payment plan. And the way that this can come up is if we're trying to incentivize an executive or an employee to come work for us. However, our company health plan has a 90-day waiting period, which is the longest waiting period that's permissible before you can enroll in health insurance benefits at the company. The executive may say, I do want to come work for you, but I want the company to pay for my portion of health insurance for those 90 days while I'm waiting to enroll in the company's health insurance. That could be either on my spouse's coverage or on a coverage I got from the ACA exchange. The company can do that, but they need to be careful not to tie that payment to any kind of substantiation or reimbursement. And they also don't want to pay it on a pre-tax basis. So the bottom line is we can provide executives with those types of payments for health insurance premiums. And the way we traditionally structure it is to say, we are making you a taxable payment. It's treated as wages, and it's intended for you to use to pay for your health insurance costs for this period. However, you can use that money for whatever you want, and we can't claw it back. We can't ask for you to submit receipts to show that you actually used it to pay for your health insurance coverage. So that's certainly an important consideration also. And then the last topic that I want to talk about is the proper tax treatment of fringe benefits. Again, oftentimes when we're entering into an employment agreement and we're trying to incentivize an executive or employee to come to our company, we may offer housing allowances, vehicle allowances, some kind of educational assistance or reimbursements. Just to think about, are we properly excluding this from taxable income, or should these payments be included in taxable income? There's likely an avenue to exclude those payments from taxable income, but there's requirements under the Internal Revenue Code to do so. And it may turn out that we can exclude it from income and need to treat it as wages and compensation. If we need to treat these types of payments as wages and compensation, how do we understand, are we going to allow the executive to make 401k contributions off of that compensation? Are we required to match 401k compensation contributions based off of that compensation? So again, just things to have in the back of your head. Just wanted to point out some very high level considerations, certainly not exhaustive. And with that, Adam, I'll turn it back to you.
DJ, thank you so much. Incredibly comprehensive as always. And I would encourage anyone who has questions about the issues that either DJ or Jeff talked about to contact DJ or the bond attorney with whom, or Jeff or the bond attorney with whom you typically work. All right, next up, there have been some relevant decisions from the United States Supreme Court. One of them was recently issued and dealt with the highly compensated employee exemption to the Fair Labor Standards Act. And here to talk to us about that decision is James Taglienti. James, welcome. And thanks so much for being here.
Yes, hello everyone. So this is my first time on the webinar, so definitely excited to be here, excited to see everyone who's attending. So as Adam said, I recently wrote an article for the firm on this highly compensated employee case, recently decided by the Supreme Court. So I'm going to go ahead and give you an overview, but I will warn you that it is a bit complicated in terms of how the pieces of the statute and regulation fit together. So I'm going to do my best to break that down and get into the nitty-gritty of the court's reasoning. So next slide, please. Okay, so the case is called Hewitt v. Helix Energy Solutions Group Incorporated. This case was decided February 23rd. And the question presented to the court was, is a supervisor who makes $200,000 annually, calculated on a daily rate, considered a highly compensated employee who is overtime exempt under the Fair Labor Standards Act? Okay, so what we're looking at here is a person who's paid every day. However, the payment every day totals up to $200,000 per year, going to qualify as overtime exempt. So as you'll kind of see from the tone of my presentation, I disagree a bit with the court. But the decision, spoiler alert, is that he is actually not a highly compensated employee and not overtime exempt. So to put that in layman's terms here, he is qualifying for overtime payment. So he will get that traditional time and a half payment as any regular day rate worker would get. So next slide. Okay, so brief facts of this case. So we have Helix Energy Solutions is the employer, or the petitioner in this case. It's an oil and gas services company that provides offshore well services through vessels. And each vessel offshore contains crews. So there's two crews primarily. One maintains the working order of the vessel itself, and then one runs the operations. Then we're going to have our respondent here, the employee, the supervisor who's making about $200,000 per year on the daily rate. So Michael Hewitt, he is a tool pusher. So I had no idea what that was before this case. I'm very happy I'm now well versed in the oil industry. Being a history buff myself, I like learning about, the history of things and, different facts and stuff. So anyways, tool pusher, okay, which is the second in command on these crews. So it's a very high level position. He is supervising 12 to 14 employees daily. His role is to ensure the safety on the vessel. He conducts the pre-tour meetings as well. So that basically means he gets everyone together who's on the crew and kind of says like, hey, these are how the operations are going to go for this particular operation and the way that we're going to gather the oil, things like that. So again, very big role. Now, in having this large role, he is making at least $963 per day, which is going to total over $200,000 per year. And I believe petitioner cited in his brief, there was a year where he made about $248,000. So he is making a significant amount of money just being paid daily. Next slide. Okay, so I am a visual learner. So when I was putting together this slideshow, I wanted to include what we're talking about here. So if you see the boats at the bottom, those are going to be the vessels that are going out to the offshore rig, right? So the nature of his job is to be on this vessel with other crew members and then go out and then make sure the oil is gathered properly and everything is in working order here. So kind of in the middle of nowhere, that's sort of part of the job. And next slide. I'll talk a little bit. I put a little thing about unique aspects of the oil industry. Michael Hewitt, the employee, he works on 28-day hitches. So what does that mean? Essentially, he works 28 days in a row, 7 days a week, 12 hours per day. So that's going to work out to about 84 hours per week. However, he is then given 28 days off. So if you think about this practically, he's only working 6 months a year. Right, working 6 months a year, extensively working when he does, but paid over $200,000 for that work. Now, I include this little bullet about days off because I thought it was very funny. Justice Alito asked a question during oral argument, and he goes, so what's the deal with this? Like, can you even take off? Can you say, can I get a helicopter to take me to go golfing? Because if you think about it, you're out in the middle of the ocean. You know, like, is it possible for you to have an off day? Is it possible for you not to report to work? And that's going to actually factor into how the court thinks about this case. So I thought it was a very interesting question because it kind of draws on what it means to work daily, weekly, and things like that. So the next slide, please. So first, I'm sure most of you are aware, but I just want to give a brief overview of the Fair Labor Standards Act. So the Fair Labor Standards Act was enacted in 1938, so a bit ago, right after the Great Depression. And the idea was we need to protect blue-collar workers from substandard wages and oppressive working hours, right? Because we have the Great Depression, people are truly suffering in terms of there's, no job stability, people are foreclosing on mortgages, general economic unrest. So it would be likely that blue-collar workers could be exploited, right? So it's like, okay, well, you need a job. I'm going to work you 90 hours a week for half the money. Does that sound good? And you're like, deal, because I got no money, right? So we want to protect these blue-collar workers. So the general rule under the FLSA is if you're an hourly employee, so say I make $20 an hour, and I work over 40 hours a week in a 7-day work week, I'm entitled to time and a half compensation. So what does that mean? I say, go back to that example, make 20 hours, $20 per hour, and I work 44 hours this week. For those 4 hours, I'm going to make $30 per hour because I'm going to make my time and a half pay for any hour over 40 hours. That's what the FLSA provides for. However, there are exemptions. So next slide. So under the FLSA itself, the statute, so section 213A1, this is all it says. So that's the general rule. However, any employee employed in a bona fide executive, administrative, or professional capacity is exempt from the overtime rule. Okay, so that's all we have. Now, for the DOL, they're going to make regulations based off of this rule. So this particular court case deals with 3 DOL regulations. So I'm going to give you a brief overview of those regulations. So next slide, please. So what is the highly compensated employee exemption, right? So I said there are exemptions. These range from administrative, executive, highly compensated, professional. So one of the exemptions is called highly compensated employee, and that's going to be defined by regulation section 541-601. Okay, and this is the legal test. How do I know that I'm a highly compensated employee? Number one, I make over $100,000 per year. Now, I just want to caveat that with in 2020, this was amended to increase the number to 107,432. But this case is pre-2020, so we're dealing with 100,000. So make $100,000. Of that $100,000, I'm guaranteed at least $455 per week. Now 684, but again, think back to the case, $455 per week. And I perform any of several enumerated supervisory executive duties. So what does that look like? Just think manager, right? I direct 2 or more employees. I do non-manual work. I'm involved in operations, communications. You're a white-collar employee. That's what this is trying to get at. Remember, FLSA drawing that distinction between blue-collar and white-collar employees. And then specifically in 541-601, we have this subsection C here, which says, quote, a high level of compensation is a strong indicator of an employee's exempt status, right? So we have a baseline here of 100,000. Our employee here, Michael Hewitt, he's making over 200,000. Okay, so just keep that in mind. So next slide. Okay, so now we have section 541-602A. Remember, as part of the highly compensated employee, you need to be paid $455 per week on a salary basis. Now, 602A is called salary basis. Okay, so what does that mean? Salary basis means the employee regularly receives each pay period on a weekly or less frequent basis a predetermined amount constituting all or part of the employee's compensation. So what does that mean? The $455, right? Regardless of how much you work, you're making $455. I take my PTO, or I am calling out, or I'm not available, I don't come into work for 7 days in a row, I'm still making at least $455. That's the idea. Next slide. So now we have 541-604B, and this is going to be the last regulation. I know, try not to cry at all these different regulations, but this is the last one, I promise. Okay, so 604B, and what is this? So normally we have to have the weekly or less frequent basis, correct, to qualify for salary basis, like it was just discussed. However, if the employee is paid hourly, daily, or on a shift basis, you could still be considered salary basis if you're guaranteed at least that weekly amount of money, regardless of the number of hours, days, or shifts work. Remember, 455. And there's a reasonable relationship between the guaranteed amount and the actual amount earned. So what does that mean? Okay, you're guaranteed $455, but in my job, I'm Mr. Hewitt, I make like $8,000 per week. I think reasonable minds could agree the number 455 and the number 8,000 is not really reasonable. However, if I'm paying an employee $455 and they only take home $700 per week, now we're talking, right? So you're going to have to look at that relationship between what do I have to give and what do I give? That's what this is really getting at. So next slide. Okay, so let's get into the procedural history of this case, right? So first we have the district court in Texas. That's our trial court level. This case comes before the court. Mr. Hewitt says, hey, I worked all these years as an oil rig manager, never got overtime. Employer Helix says, right, because you're a highly compensated employee, you don't get overtime, right? And this becomes before the Texas court. What happens? Employer wins. Court finds that the employee, Hewitt, is paid on a salary basis because his pay never falls below $450 per week, regardless of the amount of days worked. And two, he not only qualifies for the highly compensated employee exemption, but he also qualifies for the executive exemption. So when we're talking about executive exemption, think salary basis plus managerial duties. Highly compensated is $100,000. Salary basis, managerial duties. So basically, logically, if you're a highly compensated employee, you're also an executive. So they're saying like, okay, fine, you have a dispute about highly compensated. Well, he's still an executive. So no matter what, he's exempt. Okay. And now going to the next slide, we're going to see that the Fifth Circuit focuses on that first part, the salary basis. So the Fifth Circuit, they take a look at this case twice, and the employee wins both times. So in the last decision, the Fifth Circuit sits en banc. So that's a fancy way of saying every judge in the circuit is hearing the case. So the first time a panel of 3 judges hear the case, say Hewitt wins. Employer says, think about this again. Court says, okay, we will with all the judges, and still say employee wins. Okay. So instead of being very straightforward, like the district court was in Texas, they're going to make this analysis a bit more complicated. So 601, not only are we talking about the highly compensated employee, 601 incorporates by reference 602, because 601 uses the words salary basis. By using those words, we're talking about 602 as well. And because Mr. Hewitt is paid on a daily rate, we're also talking about 604B, because 604B, remember, talks about daily rate. So the Fifth Circuit is going to say these 3 regulations that I previously discussed are read together. They work in tandem, okay? And the court finds that Hewitt gets the 604B test, right? Because he's paid on a daily basis. So now we're looking at, does he make $455 per week on a salary basis? And is there a reasonable relationship? Okay, court says, does not make $455 per week, excuse me, on a salary basis, because he's not guaranteed a predetermined amount, and there's no reasonable relationship between his minimum pay and his pay. So basically the court's reasoning here is he makes, sure, $963. However, he has to punch in at least one day to make that $963. Therefore, nothing's predetermined. If he calls out 7 days in a row, he makes $0, right? That's what it's saying. So there's no predetermined amount. And if we were going to look at the reasonable relationship, there wouldn't be anyway. Again, we talked about he's making like $8,000 per week and the minimum is $450. So I believe they use the words of magnitude greater, right? He makes way more than the minimum. Okay, so next slide. So, and the winner is, right? So we're finally at the SCOTUS decision, and it's going to be the employee again. So in a 6-3 decision, Justice Kagan affirms the Fifth Circuit and essentially adopts the same exact reasoning. 601 incorporates 602 and 604, but they actually do a little bit less here. They say, okay, it's 604 because of the daily rate. However, we don't even have to get to reasonable relationship because he's not paid on a salary basis. He's paid on a daily rate. Now, the employer argued that, okay, well, 604 really only applies if we're not talking about highly compensated employees, right? We have 601. 601 fully tells us what to do. We have the sub C, which tells us that if we're highly compensated, it's a strong indicator. We have a 3-part test. Why are we looking at 604? And the court's going to disagree and say, no, he's paid on a daily rate. So we have to look at the daily rate regulation, which is 604. And that's the final decision here. So I'm going to get next slide a little bit into the dissent. Not going to go crazy, but I think it's important just for a general understanding from an employer's perspective of how to think about this. So Justice Kavanaugh is going to write the main dissent here. There's 2 different dissents, but Justice Kavanaugh gets into the analysis. He's going to say this is straightforward, right? Let's follow 601 3-part test. He performs executive duties. He makes about $200,000 per year, and he makes at least $963 per day, right? You're not taking a helicopter off the boat to go golfing. You're punching in at least one day when you get on that boat, and you're making $963, okay? That's Justice Kavanaugh's reasoning, and agreeing with the employer, 604 does not apply. We satisfied the test. No need to move on to another subsection here. Okay, next slide. All right, so I think the interesting thing from a legal nerd's perspective is what this means for administrative law going forward. So just a kind of an administrative law 101 here. Congress passes a statute, right? Then they give the authority to an administrative agency to pass a regulation, and then that administrative agency enforces a regulation. So what does that even mean? Okay, Congress passes the FLSA. DOL passes regulations based on the FLSA. Then the Wage and Hour Division of the DOL enforces compliance with the statute and regulations of the FLSA, right? If you want to file a complaint about you not being paid right, you could file it directly with the Wage and Hour Division of the Department of Labor. So this, kind of philosophically creates problems about whether, we should be able to do this from a separation of powers perspective. But I am running out of time, so I'm going to go skip a few slides here to the end. So let's get to my last slide. So I want to give you guys some good takeaways for thinking about this. So next. Okay, yeah, final thoughts. Okay, good. So our final thoughts here are this, right? So number 1, Supreme Court made it a bit more difficult for you to qualify as a highly compensated employee, right? You need to make sure you're paid on a salary basis. So my point 2 here, clearly establish how your highly compensated employees are paid. They cannot be paid on a daily, hourly, or shift basis. there needs to be a baseline of $455. Now, of course, you could contact any bond attorney and they'll help you structure a payment where you're using that as a baseline, but you're able to play around with other numbers. But keep in mind that hourly, shift, or daily is not going to fly anymore based on this decision. And of course, it implicates these larger problems for administrative law and where the Supreme Court is going forward. So thank you very much. If you have any questions, feel free to reach out. And thank you for having me today.
James, thank you so much. That was fantastic. And I would encourage all of you to read James's blog post on this case for some more information. And if you have any questions, don't hesitate to reach out to James. All right. Well, thank you everyone for being with us today. If you have any questions about any of the presentations today, feel free to reach out to those who have presented. And we look forward to seeing you next week.